Hello, welcome. I'm Michael Hussey. I'm Dean here at Widener Law Commonwealth. It is my pleasure to welcome you to our annual Jurist in Residence lecture hosted by our Law and Government Institute. The Institute helps students explore how government works and the roles that lawyers play in making and implementing law. As a result, our students develop a passion for government law, which in turn leads to Widener Law Commonwealth alumni working in all areas of government law and public service. Our alumni are key to ensuring the rule of law is rightly developed and faithfully implemented. I hope you find today's lecture engaging and thought-provoking. It is now my pleasure to introduce Jessica Collier, a soon-to-be 2024 graduate of the law school. Jessica is extremely active in our law school community. During the 2022-23 academic year, she was the inaugural Rabitz Business Advising Fellow. In that position, she worked with Professor Christian Johnson, the director of the Business Advising Program, on projects and research related to the program. Additionally, in 2023, Jessica was honored by National Jurist magazine as one of its 10 Law Students of the Year. This honor recognized her commitment to the law, to at-risk individuals, and to the law school. She also volunteers and serves the community by participating in our Volunteer Income Tax Assistance Clinic. 4 hours each Saturday morning in the spring, Jessica prepares federal, state, and local income tax returns for low to moderate income taxpayers. Please join me in welcoming Jessica.
Thank you, Dean Hussey, and welcome to our annual Jurist in Residence lecture. Honored and hosted by the Law and Government Institute, as Dean Hussey mentioned, it is also the Law and Government Institute's 25th anniversary here at the law school. Our moderator this evening is Judge Royce Morris. Judge Morris is currently serving his second Jurist in Residence at Widener Commonwealth. This year, as stated, is also the 25th anniversary. Judge Morris began his legal career working for the Dauphin County Public Defender's Office in 1991 and served as the office's chief deputy from 1996 to 1999. In 1999, Judge Morris joined the law firm Goldberg Katzman and became partner in 2002. Throughout his legal career, Judge Morris represented individuals and corporations in criminal matters and municipalities as solicitor and general counsel. Judge Morris earned his Bachelor's of Arts in Political Science at Temple University and received his Juris Doctor at the University of Maryland. He also completed an intensive program at the National Criminal Defense College at Mercer Law School in Georgia. Judge Morris, thank you, and now I turn it over to you.
Thank you. We got to try to shorten those introductions. I was a criminal defense attorney. That's what I did for a living before I became a judge, so we'll just keep it simple. But I want to congratulate Widener on their 25th anniversary. This is a great opportunity to celebrate the Law and Government Institute. It's also a great opportunity for us to participate as a legal community in appreciating that accomplishment and all the lawyers that have come out of this institution and the things that they've done in this community for law and government. We have a distinct honor of having Judge Nichols with us today. She just sat on an en banc panel of the Superior Court. We thought we might be a little late, but we made it in time. And I'm not going to give her a grand introduction and go through her resume. You can read her bio. But what I'll say is before she became a trial judge, she was a community advocate. She continued to advocate for folks who need people to advocate for them throughout her legal career, and she continues to do that on the Superior Court. And I think her character speaks well of what we want in judges. And so we're pleased to have her. And in her presentation, she's going to tell you a little bit about herself, about her path to the Superior Court, My wife always tells me everybody has a story, and sometimes if you get to know that story, it'll teach you something about them and also about yourself. So she's going to share a little bit of her story as she presents today. So I present to you Judge Nichols.
Thank you. Thank you so much, Dean Hussey, for inviting me, and Judge Morris. I'm honored to be here. So I always like to get to know my audience. How many are students here? Most people. How many are attorneys, practicing attorneys? Okay. How many have been before the Superior Court of the attorneys? It's a little bit of understanding. So what we're going to do is I'm going to talk a little bit about my pathway to the bench and my legacy, because none of us get here alone. I stand on the shoulders of many, many people that have come before me. For me to be a Superior Court judge, particularly as an African American woman, is the result of much struggle, intentional struggle, to get here. So it's important to understand, not in a divisive, polarizing way, but to understand that, as judges, we're people too, and who our background is, and who are we as we sit and hear these cases. Because as a Superior Court judge, I hear criminal, civil, family, orphans court, a range of cases, juvenile cases. So it's important, for you to understand as Pennsylvanians, kind of who am I, as I listen to these cases. So we're going to start. I think I have someone assisting me. So I'm going to go to the first slide and talk about my pathway to the bench. Then we're going to talk about Superior Court practice.
I already messed up.
You already messed up. Okay. So that's part of trial practice, is going with the flow. So that's kind of lesson number one for those of you who want to be who wants to be a trial attorney? Well, that's lesson number one. You kind of you have to go with it and go with the flow. So I'm going to talk about my pathway to the bench, then we're going to talk about the Superior Court, and then we're going to talk about some points of practice. So my pathway to the bench, I'm actually a second-generation attorney, and I was elected to the Philadelphia Court of Common Pleas before being elected to the Pennsylvania Superior Court. Is there anyone from other states here other than Pennsylvania? Okay, so quite a few. So in Pennsylvania, all of our judges are elected from the minor courts all the way up to the Supreme Court. All judges are elected. So the fact that I became a Philadelphia Common Pleas Court judge and Pennsylvania Superior Court judge meant that I stood for election to get to that process. But before that, I have quite a legacy that led me to pursue my judicial career. My dad, Edward K. Nichols Jr., is a former Tuskegee Airman. Who knows about Tuskegee? Okay, most of you. A Tuskegee Airman. Actually, before that, he worked his way through law school as a Pullman porter. Have you all heard about Pullman porters? They're quite famous. So Langston Hughes was a Pullman porter. Malcolm X was a Pullman porter, and many others. And he began his legal career as an ADA in District Attorney Richardson Dilworth's office. And this was in the mid-50s, and it was a whole different world there. As a young African-American assistant district attorney, before Richardson Dilworth, as a black assistant district attorney, you could not practice in common pleas court. So if you were an assistant district attorney, didn't matter whether you were number one at Harvard, didn't matter. The color of your skin meant that you could only practice in the municipal court and do preliminary hearings. So in other words, you couldn't do jury trials or felony trials as an assistant district attorney merely because of the color of your skin, or if you were a woman of any background. Because in the 50s, it was considered unseemly for a woman of any background to be involved in felonies and things of that nature. So if you were a woman or if you were a person of color, you could only handle municipal court cases. So my father's group of assistant district attorneys, they were the first group of attorneys of color that could actually practice in common pleas court. Now, it may not sound like much today, but it was a big deal in the 50s to actually practice law. So, just being a lawyer, just practicing law was so difficult back then. as a person of color. And here's a picture that I actually found of their 20-year reunion. So there's Richardson Dilworth. I don't know if you can see my finger here. I don't have a laser. Okay, we're not going to get that deep. But anyway, Assistant District Attorney Richardson Dilworth is there. Third Circuit Judge, future Third Circuit Judge, Leon Higginbotham was also in this group. Federal Judge Clifford Scott Green, Common Pleas Court Judge Harvey Schmidt, and many other notables came out of this group of assistant district attorneys in the 1950s. Okay, go ahead. So after leaving the district attorney's office, my dad joined the law firm of Austin Norris, and the Austin Norris law firm was recognized as the first Philadelphia black law firm. And Austin Norris was actually quite a character, quite unique. He had newspapers. He was a newspaper man. He had a newspaper in Pittsburgh that he was running, and he had this law firm. And he was such an excellent. This firm was known for its excellence in trial advocacy, because at that time there weren't many non-diverse judges or jurors, for that matter, in Philadelphia, and they were able to win these cases. He's noted for leading the change in the Pennsylvania bar examination process. Many of us take for granted, many of you will take, anybody taking the bar coming up this summer? Well, when you take the bar, you're assigned a number. Back in the 50s, they had your picture and your name. So the people of color ended up not passing in many cases. And it was a 20-year fight for the Pennsylvania bar process to be what it is today. We just take it for granted, because even in my time, it was I sat down and took a number. I had a number. Nobody had my name and picture. So we take for granted these things that take away any opportunity for bias or improper consideration, because people have your name and your picture during the bar process. And many notable practitioners became judges and civic leaders, including, I mentioned some of the names, but also State Senator Hardy Williams is another notable that came out of this office. Many of the Richardson Dilworth ADAs went to Austin Norris's firm and then went on to become judges and civic leaders. Go ahead. And actually, my dad practiced law for over 50 years as a criminal defense attorney. And before I talk about the Superior Court, that's where I learned about law. He had his own practice, and then my older sister also became an attorney, and they had a firm. So I had an occasion to go to court with them, and I remember a case, and some might have heard this, but I remember a case where a person not much older than me, but not a minor, was charged with a very, very serious crime, actually felony murder, where a boyfriend had committed this crime, and she was along with him. And I remember seeing, that could be me. That could, that could be me in that position. And my father, I just noted, he was like her only friend, her only champion in the room, taking on all the weight of the state against him. This is Commonwealth versus this person. And he is, with all of his might, championing his case, before this jury. And that really stuck in my mind, the power of that's what the justice system is, the virtual David versus Goliath against all the odds, standing up. And of course, what she was involved in certainly wasn't right, but she's still entitled to due process. She's still entitled to a fair and impartial trial. And he was fighting with all his might. So of course, as a young person, what do? Run in the other direction. So I ended up going into art or something completely away from that. I said, I'm never going to do that. Oh, goodness, no. Because the seriousness of it, the somberness of it.
Well, let me ask you this question, since we're so what drove you back to law? So what was it that took you back to the legal
even
profession?
Pursuing art school, you can't get away from law. Law is in you buy a car, what are you signing? An agreement. Or you lease an apartment, there's no escape. You can run, but you can't hide from the law. You know, you're leasing apartments, you're buying things, you're mortgage on your home. So I began to understand in my flight that still, you know, I needed to understand the law. So my first idea was, okay, you know, after doing, different jobs, yeah, to go to law school, but to use it maybe for arts law or use it, for other kinds of law. But then once I got in school, I really started seeing the importance of, standing up for justice, that the fight is not over. You don't have to necessarily be in criminal practice to, fight for justice, but in many, many aspects, of our life, consumer protection and many other places, even the arts, an artist to understand what's going on with, what are they signing, to get into agreements to sell their art, whether they're a performing artist or whatever it is. So that's how I started to really understand the importance of it. I got into school. I got involved. I was always interested in government. So a lot of my career was in city government, and that's important to make sure that our government works properly to serve the citizens. I got very interested in public service, and the judiciary is just an extension of that, because the judiciary at its heart is public service. Many may not see it that way, but that's what it is. We're public servants, and we're here to perform our duties under the law. So I started to understand that, and then I went through a couple of campaigns of other people running for judge. After doing different kinds of practice on my own, having my own legal practice, and doing and trying different things, moving out of the state and coming back. So I saw what was involved with running for judge, and I said, okay, I get that. I see what I need to do, raise the money, the political support and all of that. So I realized at a certain point in my legal practice, having worked in city government and on my own, I wanted to take the next step and actually, become a judge. And having seen many of these people, Judge Higginbotham and Judge Clifford Scott Green, and the importance of that legacy in the judiciary, I decided to follow forward with that. The only regret is, my father wasn't here to see, my pursuit, of the judiciary. So I was able to run for the Philadelphia Common Pleas Court, which is our trial court, and we'll explain the different levels of court. I was successful. After about 6-7 years of that, then I pursued the elective process to come to the Superior Court. And I am excited and energetic about what I do, and doing my best to serve people. We're not just all seeing or all knowing, nor do we think that we are. So it's a learning process every day. Every day we learn, because the law is always changing and evolving. That's what's exciting about law. It's not in stone. The law is always changing and evolving.
Just another quick question before you start getting into the structure of the court. What kinds of things, kinds of qualifications do you think are really essential when you're on the Superior Court or any appellate court?
Well, it's really no different than being, on the trial court. Of course, you have to understand the trial process, because people come to the appellate court. Some have been judges like myself. Some have served as common pleas court judges or magistrate district judges, or in Philadelphia municipal court judges. But there are some that have been elected to our court that have not served as judges. They come as lawyers and run for the appellate court and have been successful. You need to understand the mechanisms of trial, whether you're a lawyer and you run or as a judge. You have to understand, in my view, the trial process inside out. Not just the legalities of it and the case law of it and the rules, but what's supposed to happen in a courtroom and what's not supposed to happen in a courtroom. I think that is fundamental to being successful in any level of court. that you can bring procedural justice, meaning that people come into your courtroom and they know that it's going to be fair. They may not like the outcome, but they know they've been heard, that they've been respected. The court, first and foremost, should be a place of respect at any level of court, whether it's a magistrate court or the Supreme Court. The people coming into the court, number one, should know that they're being respected, no matter who they are, no matter what their background. It's not just certain people come in and get treated favorably and others disfavorably, but everyone should be treated equally when they come into a court with respect. And that means them being heard. It means that there's transparency, that the judge is explaining his or her rulings, and it may come in our court. Our explanation of what we do is in a written form, so there's an opinion. Other judges will explain what they're doing maybe from the bench, but there should be transparency in what's going on, in a courtroom. So they're basic. It just really comes down to respect, the understanding the humanity, of a courtroom. That no one wants to be interrupted, certainly not screamed at. A lawyer as well. Lawyers have feelings too, contrary to what people may think. But no one deserves to be belittled, screamed at. Just basic human courtesy. So the place should be a place of safety. So witnesses. I know before I came to this court, the Superior Court, I handled almost for a 2-year period, pretty much exclusively sex cases. So you had involving children. So you had, in a lot of the cases, so you had people that were traumatized and they're coming into the courtroom in a certain way, families. So you had to maintain order in the courtroom. You had to make sure witnesses were not being intimidated, that people could come and speak their truth, in the courtroom. And then the jury will decide if it's a jury trial or if I'm deciding it as a bench trial, then I can decide it. But first and foremost, you want people to feel safe when they're coming into a courtroom and not intimidated, not forced, not disrespected in any way. And then, of course, obviously the lawyer or the judge doesn't know what they're doing. I mean, you have to know the law, obviously. But these kinds of intangible things, I think, are very important. So coming to the judiciary, I think it's important to understand those things. So those basic respect undergirds everything that we do, because otherwise there's no credibility. And there have been studies, this isn't just touchy-feely stuff. There have been all kinds of studies to show that if participants in the court feel respected and heard, they're more likely to comply, and you get less violations, of probation, for example, or less because the person understands that they're being treated as a human being, as a person, and not being treated as just an accused, a defendant, but everybody's treated equally, that you're not showing preference, because sometimes you'll hear horrific things in a courtroom, things like child pornography and things, unspeakable things you don't want to think about. But as a judge, you have to be impartial and professional to hear all sides of the issue before making the decision. So I think that's the most important thing in my mind for anyone sitting on the judiciary, especially at the appellate level, because you're getting the appeals. So you have to figure out what happened in the courtroom. Why didn't the lawyer raise a certain issue, and is that waived? Well, if the judge is cutting them off, which they can't raise the issue because they're being cut off, or that kind of thing. So you can begin to understand how this case got to where it is on the appeal. So it's deeper than just regulation, statutes, and case law. It's about understanding human nature, and sometimes it doesn't hurt to have a little bit of common sense. Throw that in there too. Not exclusively, it's not based on common sense, but it's important to have all. So those intangibles make a complete judge that's fair, impartial, independent, unbiased, and on the merits understands the law and is following the law. because we're not the legislature, and we're not here to create law. That's the legislature. So we're here, to follow the law to the best of our ability, interpret the law as best we can in deciding our cases. All right. So this is the breakdown of the Pennsylvania court system. It may, for some of you that are out of state, there may be differences. But the first, what I call my first responders are what's called the minor courts, which are the municipal courts or magisterial district courts, preliminary hearings, smaller civil matters are handled at that level. The courts of common pleas, which is the trial division where I was before I came to Superior Court, here's trials in civil, criminal, family, orphans court, and all of the different matters. It's a court of general jurisdiction. They have jury trials, non-jury trials in civil or criminal matters. And the appellate division is the next division. And the state of Pennsylvania, to my understanding, is the only state in the nation, my understanding, that has two intermediate courts. Usually there's one intermediate court, but in Pennsylvania there are two. It's the Superior Court, which has existed since 1895, where I am. That is appellate court as of right. So in other words, if certain prerequisites are met as a matter of right, individuals aggrieved on the lower courts can appeal to our court. The Commonwealth Court was carved out in 1968 by the 1968 Pennsylvania Constitution, is a court of limited jurisdiction that only hears certain civil matters, primarily governmental appeals and other matters. And then, of course, the Supreme Court is the court at the top of the pyramid that has supervisory jurisdiction over all of the courts, over all of the lawyers, and operates a discretionary appellate review. So to give you an example, our court is one of the busiest courts. We say it's the busiest court in the United States, with anywhere from 4,000 to 8,000 appeals a year coming to our court from 67 counties. Our sister court has about half of that. The Supreme Court, because it exercises discretionary review, may only allow 300 or maybe plus, or around on that range, maybe 300 to 500 cases per year that our Supreme Court will hear those cases. In addition, the Supreme Court operates through boards, commissions, and rules committees, and develops all the rules and operating procedures for all the courts, bar admissions, who can be admitted to the bar, has supervisory jurisdiction over all the attorneys and judges. There are disciplinary boards and courts that deal with misbehaving attorneys as well as misbehaving judges, because no one's above the law. Everybody has to follow the law. So all of that is under the administrative and supervisory jurisdiction of the Supreme Court. Okay, next. Okay, we kind of went through some of this, and this provides, watching our time, some of the detail. We've been in business since 1895. There are 15 commissioned judges, meaning elected as a commissioned judge, and 3 senior judges. You can sit as a senior judge if you sat as a commissioned judge for 10 years and haven't reached the age of 78. Currently, the mandatory retirement age for commissioned judges is 75. And as I've said, all judges stand for election, and we're a statewide court. So we sit in Philadelphia, Harrisburg, in Pittsburgh. There's 3-judge panel, merits panel that hears the appeal initially. Then there's what's called an en banc or re-argument process that litigants that are still upset with, if they don't like the 3-judge panel decision, they can seek to have 9 commissioned judges of the Superior Court hear their case on re-argument. If they're still not happy, they can seek the discretionary review of the Supreme Court. And these are all the areas that I mentioned that we cover. All right?
Now, let me ask you this question, since you were on en banc panel today. How do they establish which 9 judges are going to be on the panel? Is there sort of a lottery system, or is it voluntary? Is it?
Well, generally, the president judge assembles the panel, and there may be, unavailabilities. Certain judges may be not be available for different reasons. So between schedules, or they may have a conflicting 3-judge panel during the time, because all of this is happening, at the same time. So the commission judges are also hearing their 3-judge panel cases. So judges may not be available because they're on a 3-judge panel. That's why only 9 of the 15 commission judges are assembled instead of all 15. Because people get sick or people retire. And recently we had one of our judges ascend to the Supreme Court, so that we have a vacancy, or people retire. So that's why it's actually in the believe in the Constitution that it's a 9-judge panel. Now, in the remaining time, I know there aren't many lawyers here. We're going to talk a little bit about the Superior Court practice, like practice pointers with briefs and arguing, before the court. So hopefully for the students it'll be useful, maybe at some future time. But the important thing to remember for everyone is that appeals are won at trial. That is the most important thing. Appeals are won at trial. We tell lawyers all the time, we're not the 13th juror. This is not a redo. An appeal is not a redo of the trial. That's not what we do. The scope of appellate review is primarily limited to the trial below. Was there an abuse of discretion? Is there something inconsistent in the record? In other words, is the judge's decision inconsistent with the record? Or is there an error in law? In either jury instruction, evidentiary ruling? What is it that the judge got wrong? That's primarily what we're concerned with, because it's important to understand we're not a court of record. We don't have a stenographer. Our whole world is we're in the box. We're in the box of the record below. We're not blazing new trails outside of the record. We're not creating a record. We don't hear witnesses. That person lied. Well, we don't know that. We can't make that judgment because we didn't hear that person. Credibility determinations are made by the trial court judge. The trial court judge heard that case below. If it's a jury trial, that's what the jury did. The jury made those determinations. We don't revisit that. Now, the argument is, well, it's against the weight of the evidence because that determination was so out of line with the record, then that's something certainly we can deal with. But before we even get there, what's important is timeliness and issue preservation. Without going through all of the rules, you can see here there's certain prerequisites, there's certain post-sentence, post-trial motions that have to be made. A notice of appeal has to be filed in a certain time frame. There's even nunc-pro-tunc. In other words, you can clean up a mistake below. The trial court kind of blew it and said, okay, well, what we'll do, trial judge, is I'll grant nunc-pro-tunc, and you can file your appeal or your post-sentence motion because there was a breakdown somewhere in the court's operation. And then issue preservation. You have to preserve your issues below at trial. We're not going into all of the down and dirty. You can see some of the points in the outline. Okay, next.
And just as when we say issue preservation, I think the average lawyer thinks about big things. But during the course of the trial, there are a number of things that happen, right? Like objections and, just raising issues that may not be apparent on the record. For instance, a judge rolling their eyes or doing something that you can't necessarily see on the record unless the lawyer is bold enough to say, Your Honor, I see that such and such is going on. Or the sheriff standing directly behind, the defendant, making it clear that he's in custody. Things like that. You have to be bold enough to be able to create the record that may not be apparent because you're not going to see that.
We can't, we weren't there. And we'll get lawyers go on and on painting the picture, this happened, that happened. And the question is it in the record? If it's not, we can't consider it. And that's a very important point, because we always tell trial judges, the record is your friend. Paint the picture. You know, if a defendant is jumping up and down and acting up, you have to say that. You know, the defendant, I note for the record, defendant's doing this, defendant's screaming, defendant's doing that, and preventing me from, conducting the proceeding. You need to create the record. As he said, counsel needs to say, for the record, Your Honor, I just want to create the record. We tell lawyers all the time, don't be afraid to say to the trial judge, look, I'm just here to create a record. I'm not here to challenge you. I have to create the record. And as a trial judge, I can understand that. You can understand that the lawyer needs to create the record, that they objected to a certain jury instruction. Because guess what? If it wasn't objected to below, what do you think that our court can do about it? If it wasn't objected to below? Nothing. Because it wasn't preserved. We would get these beautiful legal arguments about this and that, but did you raise it below? No. It wasn't raised below, so that means that issue was not preserved for us to even consider it. We don't even have the jurisdiction to consider it. It's waived. So those are the kinds of things that's very important, because remember, you have to create verbally so that the stenographer can get that down, the picture. You have to paint the picture for us, not in a disrespectful, argumentative way, but you have to have that on the record. Otherwise, it didn't happen. If it's not in the record, then for us, it didn't happen. You can't argue to us what's not in the record. And here are some other points here that, for time's sake, we're not going to necessarily go through all that, but you can go look at it. Timely objections. After the appeal has been filed, things that you need to ensure that are happening in your brief. Okay, next page. Post-sentence and post-trial motions are very important. Post-sentence, obviously, in the criminal context, post-trial motions in the civil context, to make sure, again, that you're noting your objections to whatever happened at trial that, in your view, is objectionable, and that's put before the court. Because the importance of that is not just a hollow exercise. The importance of raising it below with the trial judge is the trial court can correct its errors. I know as a trial judge, sometimes things get missed, or if there's something wrong with an order or something you didn't catch, someone raises it to you below, you can make that correction. And contrary to what a lot of lawyers may think, judges do make corrections if points are raised to them, but it's how you do it, in a courteous, respectful way, in a professional manner, not screaming and accusing the judge of all kinds of stuff, but there's a way to do it to get your point in. And sometimes things can be corrected. And then there's other things. I mean, in the criminal context, sometimes the criminal defendant might launch out into their own motions and filings. They want to be co-counsel, and of course that's not going to work. That's a legal nullity. If the defendant is represented by counsel, then we only address the counseled filings, except with the notices of appeal, because that's a constitutional protection. So even if the notice of appeal is filed pro se, then once the attorney comes in, the attorney can take over from there. But the statute of limitations and things like that are told. The proper time periods are told, because that filing, in other words, is not disregarded. And there's some other points that you all can look on later, which are probably more down into the weeds.
Can I ask you a question? So non-pro-tunc relief, I know as a trial judge, oftentimes where I see an issue that I know may later on create an ineffective assistance of counsel claim, I'll grant the non-pro-tunc relief and allow them to appeal, so that it doesn't create an appeal 2 years down the road.
Exactly.
Is that appreciated by the Superior Court?
Absolutely. We love it when the trial court corrects, mistakes, and there are court breakdowns or things get missed, or like you said, you don't want to facilitate an ineffectiveness claim. So that I love it. When we see that, because by the time it gets to us, it's too late to do any of that. Okay, next slide. And the things you want to avoid, most of all, as an appellate attorney, is quashal, dismissal, and waiver. That's the unholy trinity. 'Cause that means your case is being thrown out, so you don't want that. So here are some points. Quashal goes more to jurisdictional concerns of our court. In other words, we can't hear an untimely appeal. Things that are untimely are quashed because we can't hear them. And dismissal, like it's admittedly there are cases where quashal and dismissal are close, so if it's not a quashal, it's a dismissal. And waiver, which I just talked about, if things aren't raised timely, if they're not preserved, then they can be waived, or they're not in the appellate brief, or the statement, 1925B statement, which is a statement of errors complained of by the appellant. If certain issues aren't there, but then appellant starts talking about those issues in the brief, it's waived. The 1925B statement is very, very important because the court files its 1925A opinion in response to the 1925B statement, which is telling the trial court what he or she got wrong, what the court got wrong. And if the issue isn't there, then the trial court can't respond to it. So there are things that can facilitate waiver, and we're not here to play gotcha. You know, that's not what we do, like, aha, you know, out of here. You know, that's not the game that we're interested in playing. So we want to make sure that everyone has the opportunity to waive their issue, to present their issues and avoid waiver, so that we can resolve it. Go ahead, next.
And I think this is the one thing they talk about in law school a lot is sort of that issue spotting and being able to spot issues. So, you know, this is where that plays out in the real world. You know, you gotta, before you file your statement of matters complained of on appeal, you've got to identify what issues you think are need to be raised. Otherwise, you're going to lose the right to argue those issues when you're doing your brief.
Right, and there's some more technical things about pre-briefing schedules, docketing statements, and post-briefing, and it's probably really down into the weeds. So you could certainly review that. Going to the next. So throughout the appeal, you want to check the docket because sometimes, particularly if you're dealing with litigants that kind of file stuff on their own, you might look on the docket and see things that have been filed that you didn't even know about, which can happen. So you want to check the docket to make sure what's going on. Of course, orders from our court, you can, in the PACM system, obviously we have a electronic filing so the attorneys can go in there. All parties, we have quite a few pro se litigants that litigate in our court. Some may or may not have the understanding or the technology to get in there. So we got to understand the electronic filings. We got to make sure to the best of the court's ability that people get notice of what's going on in the court. And these are just some points about that. Next.
And
I'm trying to keep mindful.
A question about that. So oftentimes when an appeal gets filed by somebody, self-represented person, and it's filed improperly, rather than the trial court doing a 1925 or whatever, we would send a correspondence to your court indicating that this appeal was not properly filed.
Yeah. Or the trial court hasn't been served with it. Yeah. Which is very, very common. Yeah. That it's filed with us, the notice of appeal, but it's never served on the court or anyone else for that matter. Or if it's a criminal matter, the Commonwealth wasn't served, or if it's a civil matter, other parties weren't served with whatever the filing is, and that happens. So we want to make sure as much as possible that it's an even playing field for everyone. But so in our rules, there is the ability to correct these defects, but if the parties are not willing to correct the defects, whether they're represented or not, after a certain point, the case, you could end up with the case being dismissed. All right, and these are some other technical things about published opinions and memorandum opinions and unpublished memorandum and how they can be used. So this is another point for practitioners. So
Let
we
me
won't
just get your
delve too much in it.
opinion on this. So an unpublished decision, we would say it's non-precedential.
But it could be persuasive.
But it could be persuasive. So if I were to file a brief to the Superior Court and I put a bunch of cases that were, not published, but I felt were well reasoned by the Superior Court, how do you look at that as opposed to a precedential decision?
As long as it's after May 1st, 2019. If the memorandum is before May 1st, 2019, then we really can't consider it. But the court as well, we're constantly writing and researching as well. So obviously, as writers ourselves, we use unpublished memorandums post May 1st, 2019 for their persuasive value. Only opinions have the precedential binding power that we have to follow an opinion. Unless it's, for example, the en banc can overrule a precedential opinion of its court. But if in a 3-judge panel, I can't, as a Superior Court judge in a 3-judge panel, overrule a precedential opinion. And obviously, if the precedential opinion is from the Supreme Court, you can't overrule our Supreme Court. You have to follow it, like it or not. You may very much disagree with it, very much. But we're not here because we agree with the law. We're here to follow the law. So the law has been set, established, the precedents have been established, so we have to follow. In fact, even today, and it's been televised, so I can say it, there was a precedent I did not agree with, but I had to follow it in a case. And that's...
Did you say that during the televised?
Absolutely. We said it, that we have to follow the good, the bad, or the ugly. Those are my words, and it's on the broadcast, so I'm not speaking out of school. We're duty-bound to follow precedential opinions, the good, the bad, or the ugly. And of course, those cases can be overturned or overruled in certain circumstances. Like we can overrule in an en banc our opinions, but of course we can't overrule a Supreme Court decisions. There may be some distinguishing points that the facts are different, and we can distinguish it. But we're here to follow binding precedent. That's part of our responsibility, as a judge, to do that. All right, next. And these are just some points about filing to make sure you avoid a waiver. That's a little bit more technical, so I don't think we need to. In the time we have left, I want to leave some time for questions. Keep going. And there's some more points you can look at later. A lot of this has to do with, avoiding quashal in filings. So let's keep going. Okay. So these are some of the essentials and important briefing considerations. Making sure that you follow the rules of how the brief is supposed to be set up, how authority is supposed to be cited, not relying on boilerplate, organizing the argument sections in the same order as the statement of questions presented. Now, this may sound like, well, isn't this obvious? But the obvious isn't always obvious because we get plenty of briefs that do not follow the proper format, and it's very hard to figure out sometimes what exactly is being argued. There's word limits, and you heard me talk about the 1925A, 1925B statements, and the 1925A opinion of the trial court, making sure that's attached to the brief so that we don't have to go hunting for it. Okay, next slide. And these are just some other considerations about arguing, and you don't have to make your argument argumentative. That's a good point. Don't make it too personal. This person is a liar. No, we can't say that, but people will say that, things like that, and that's not persuasive. Yeah, you know, that's not, no. So you want to keep your argument professional, you know, avoid, that's why it's good not to represent yourself in some things. You're so close to it, you don't have your, you know, impartiality as you prepare the brief. Next.
Now, I think there's a very good point in D when you say your statement of the case.
Keep it neutral.
Because a
Don't
lot
make
of
it
times
personal.
in briefs that I see coming back on cases that I have, the statements of the case are very slanted to their side without just laying out the facts and you know, the general statement of the case. And I think your court probably
Right.
looks at that with
Or
disfavor.
personal attacks against the parties or the judge. That's not persuasive. Okay, next point. Now, oral argument. The first thing is to determine if oral argument is necessary. Approximately 10% of our cases, maybe a little more than 10% of the cases are argued simply because of the volume and because of the location of the courts. It may not make sense logistically to argue. So you don't want to argue for argument's sake. Most of our cases are submitted. In other words, they're determined. We determine them on the briefs. And we take cases determined on the briefs just as serious as we do the arguments. So we want people to understand that. And then during the argument, there's either standard, which is a 15-minute argument, or 5 minutes, which is our expedited.
Before you leave that, I always had a question about that because I would take expedited argument on like a one-issue situation that I really just thought I wanted to just argue that one issue very strongly, and then just touch on a couple of the other issues briefly. Is there any, in your minds, is there any difference between that 5-minute argument person or that 15-minute argument person in terms of their seriousness about the issue that they're raising for the court?
Absolutely not, because a lot of the cases, you should be able to talk about your case in 5 minutes. You really should. That whether you take advantage of the standard argument anyway, you know, the elevator speech, you should be able to get down to the salient points, because every point is not equally important. So you want to prioritize your most important point, because it's important to understand the point of the oral argument. The oral argument is really for the judges. It's really for us to gain more understanding about the issues that the litigants think are important from their perspective. Now, we may not end up agreeing with the litigants, but it's important for the litigants for the litigants to present to us those issues that they think are important. So everything isn't equally important. We have the briefs, we have the record, so we're going to go through that thoroughly. So you know, you don't have to go through rehashing the facts and that kind of thing. You want to get down, as I said, to the nitty-gritty of what your case is about. What is the most important point of your case that you want us to understand from your perspective? So argument can be very useful. So the expedited can be very useful. But no, we don't take one, because a case is expedited, that it's less important than a standard argument. They're all equally important. Okay, next, we're getting down to, okay, and these are just some of the mechanics. You know, focus on the controlling principles of law and fact. We don't want to hear about all the law that you know in this area. We want to get down to the controlling law and facts, and be respectful during questioning. This is one I want to really highlight because people get carried away. Sometimes lawyers, as well as self-represented litigants, you know, get so wrapped up in the passion of the case. You know, they're interrupting judges, screaming. So when the judges speak, stop. You stop. Do not interrupt. Wait for the judge to finish. Because what I always tell litigants, if I'm presiding, is, look, we're not here to wade into the fray of your case. You know, that's not why we're here. We're here to understand. So it's to your advantage to listen to our questions and answer our questions, because that's helping the judges understand what is important about this case from all sides. So if you're interrupting the judge and screaming and hollering, that's not going to help your cause, because we're not in the fight. We're not here to pick sides. We're here to apply the law. And here are just some other, you know, kind of obvious public speaking points, loudly and clearly. A lot of people come up to the microphone and mumble. You can't hear. what they're saying. And of course, anticipating the opponent's arguments, the judge's questions, and be truthful to the court. This is a good point. Don't make stuff up. Your credibility is the single most important, as a lawyer and as a litigant, even if you're self-represented, the most important arrow in your quiver is your credibility. And if you lose your credibility, you can't get that back. So don't lie. Don't lie to us. If you don't know something, say you don't know. There's no shame in not knowing. Don't make it up, please. If you don't know, you don't know. If you're the appellate lawyer and maybe something took place at trial and you don't know what took place, and say, well, Judge, with all respect, I wasn't in that part of the proceeding. That's not in the record. So I can't speak to that point. That's fine. Anybody can understand that. But the worst thing is to make stuff up. And then later we go on the record, that lawyer lied to us. That's not cool. So you don't want to do that. Know the standards of review, argue accordingly, know the record inside out, especially if you're not the trial counsel. No, don't come to the microphone and say, hey, I wasn't the trial counsel. No, it's your job, if you're before us as arguing the case, to know that record inside out. And that's all we can expect of you. Anything?
And if you don't know the standard of review, you may need to lie on that one.
Yeah.
Because you're in trouble.
You're in big trouble. I think, is that anything else? Okay. So, there's still a couple things, so let's go through them quickly. Go ahead. Reconsideration, as I just mentioned, is the 9-judge en banc panel. Let's go through that quickly, because I do want to. And these are just some other public policy, access policy considerations. Keep going. And confidentiality certification forms. Confidentiality may come to play if representing a minor. There might be children, fast-track cases, where certain matters have to be kept confidential. Even names might have to initial names, or part of the record might have to be sealed. But there's more information about that. And that's it, and I'm available for questions in the remaining time that we have. Anybody have any questions? Okay.
The majority of women judges, is that correct? So I was wondering if you could just talk a little bit about the significance of that achievement, and if it feels any different at the court, or if it led to any changes, or.
Well, it's you don't want to generalize about women and men, but generally speaking, women tend to be more consensus builders. So you don't have that kind of all or nothing, win and loss approach to things. Because I remember when I first came on the Superior Court, it was a very different composition. So I noticed the tone, the arguments and things have changed because there's much more of a consensus. But people disagree, of course, still disagree, but the manner of dealing with each other kind of follows along that kind of coalition building consensus idea, because generally now, many women are the way, because I'll just say for myself, that's the way I am. I'm definitely interested in a consensus, collaborative approach, to things, but you have to do what you have to do. You have to apply the law, you have to follow the law, and it can be painful, but you have to do it, and we each have to write our individual cases, but it's just a matter of, you're not just by yourself out there. Your colleagues join, can concur, or dissent. So you have to have good social skills, you have to have good people skills, you have to play well with others. And that's one big difference between, I think, the trial court and the appellate court. Having been a trial court, you're a lone ranger.
You don't play well with others?
Well, you're by yourself. You make your decisions. Good, bad, or ugly, rise or fall. You make your, admissible, not admissible, guilty, not guilty, whatever it is. And, of course, dealing with a jury, you make your determinations, what goes back with the jury, what doesn't. But you're kind of more joined at the hip when you're at the appellate level. So your social skills or lack of them in some cases, become more highlighted, let's just say, because you're working with each other more than, at the trial level. So it's a different dynamic, than at the trial court.
I think we have time for one more question, and then we'll wrap up if there is another question.
Mhm.
How often have you, since you've been on the Superior Court?
I don't know exactly how many dissents in the 7 years, but I just say I dissent when I feel a dissent is due. If I disagree, then I'll dissent. I mean, and that's what it is. But the thing I do like about this particular court, even the composition of it, male, female, is you can disagree without being disagreeable. If you have to dissent or you feel that you have to dissent, you do what you have to do. And that's what it is. And then on to the next case. Yeah. Anybody else? I think we have
And I apologize. There were some people in the chat, but I don't know how to.
Do you know how to?
It's just, there's
No question.
reminding the
Oh, okay.
There's no, anybody else have one?
Learning, overcoming it, or facing it?
Public service. Well, sometimes dealing with the general public can be challenging. I think the most important thing for me is to be mission focused. Why am I here? Why am I doing this? I'm not here to please people. I'm not here to make friends and influence people. I'm here to carry out my role. When I was in city government, I was there to carry out that role. And now as a judge, I'm here to carry out that role in a respectful, professional manner. And I have to keep that in front of me because you deal with very emotional things as a judge. I remember one story, I know our time is almost up, as a trial judge, when I was dealing with a lot of the sexual abuse cases. I'm going to a supermarket. We do go to the market. We do laundry. We do everything everybody else does. I'm going to the supermarket, and I'm in line, and someone comes up to me, "You're a judge, aren't you?" I'm like, uh-oh. Now, this could go several ways with this, because some have come up to me, you're my judge, you're my probation judge," or something. And I said, yes. She said, "I just wanted you to know you presided over a case, and my 7-year-old child, was sexually abused. And, she got justice. And I just want to thank you for the way that you conducted the trial." And just like that, so it hit me, the real of what we're doing. We're not playing games here. I tell my clerks, because we don't see the people, we never want to think they're like characters in a novel, because you're so removed, it's easy to lose the humanity. But this woman brought me back. These are real people going through real things. A parent's worst nightmare. I don't think I could imagine anything much worse than that, other than if the child had been killed. And something that I did helped her through that process. I can't undo what was done, the evil that was done, what happened. But what I can do as a professional public servant that's committed to justice is do what I'm supposed to do in the best way that I can. And that's what I do every day. I think of her and I say, every day, I want to come in here and do the best that I can do every day to serve the people of Pennsylvania. So thank you.